All right, my friends, I just pressed the Let's Go Live button, so let's wait for the stream to fire up all across the fruited plain of the internet. Before we go ahead and get started, we've got to make sure that the tubes are connected. Otherwise, we're just rambling off into the ether somewhere. And it looks like we are alive on YouTube. We're alive on Rumble. We were already up on the locals. Should be good on Twitter. Let's get right to it, my friends. Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gouveia. I am a criminal defense attorney broadcasting from the Valley of the Sun, deep in downtown Phoenix, Arizona. And today we're talking about challenges. We've got two cases to dig into. We've got a very curious fallout situation. Yesterday, we spent a good portion of the program talking about the Durham Report, 300 plus pages of different materials that we went through page by page. And we've had some time to process it, as have some other people. When we wrapped up with the show, we were asking ourselves, so what? What are we going to do with all this nice new information that really isn't that new? Is anything going to happen? Is somebody going to do something about it in Congress? Well, we know the FBI is essentially a corrupt agency at this point. And so Marjorie Taylor Greene has filed articles of impeachment against Christopher Wray, the director of the FBI. And so now we have something on the line. We can see what the other Republicans say about it. Even if her articles of impeachment don't go anywhere, at least we're going to start to see some people take a position. And Josh Hawley also was saying this, that there needs to be prosecutions of FBI agents or of people who were involved in this malicious activity. And even Tapper agrees that this doesn't look good for the FBI. So that's all in the fallout. Now, simultaneously, I know there are a lot of conservatives out there thinking that this thing was a home run, and there are many Democrats on the other side who agree it is a home run for them, not for the Republicans or the conservatives. Andy McCabe was on with CNN. He's doubling down on that. Our investigation was perfect. He says John Durham's report doesn't allege any criminality at all, doesn't even offer any real policy changes. So I'm vindicated. So he's talking that way. FBI says, we're good. We already made the changes we need to make here. Thanks for the letter, but don't write again. Okay, we're good. We're not going to make any changes. We'll review their statement. Peter Strzok, one of the FBI lovers who says, well, stop him, when he was texting with Lisa, the other FBI lover, said, we're going to stop Trump. He's out there gloating. He's saying, well, nobody got convicted on our side. Our side convicted your people, but your side didn't convict our people. And so the scoreboard is what he is referencing. So they're all slamming the football on this, spiking the ball. And CNN is doing the same thing. Look at this photo they used of Hillary Clinton on their Twitter account. These people, they're gloating. It says that Durham concludes that, quote, did not, all things considered, amount to a provable criminal offense. So you see the whole report. The only thing they glean from this is that no criminal charges. They think that they're totally vindicated. So, all right, we'll go through that. And apparently it looks like the Durham investigation is officially closed. Merrick Garland sent a letter over to Congress. We'll take a look at that. And then we'll, of course, review the actual articles of impeachment, where Marjorie Taylor Greene details out why Christopher Wray from the FBI, the director of the FBI, must be impeached. And again, whether this goes anywhere or not, who knows. But we'll see where Republicans fall on this issue. Time to take a position on it. Now, we'll go through all of that in the first segment, and then we have to turn our attention over to Kari Lake stuff because, boy, oh boy, we are scheduled for a trial tomorrow. We are going to be covering it live, so if you're not already subscribed to us wherever it is you're watching this currently, please do that. Make sure you hit the notification bell because we're going to be going live at about, well, definitely before 9 a.m. Arizona time, probably about 8:30 Arizona time, which will be 11:30 Eastern time, because trial will start at 11 Eastern, which would be, no, you do the math, noon. 11:30 Eastern is when we should go live, and then the trial should start at noon, 9 a.m. here, noon Eastern. So we're going to be here live covering all 3 days. Wednesday, Thursday, Friday, we'll be here. Then we've got the Kari Lake trial prep. So today, in order to get prepared for trial, we've got to go through a whole slew of filings. A ton of stuff hit the docket yesterday, including last week we covered the status conference where there were several oral arguments proffered, and we now have an under advisement ruling. Remember, the judge didn't give us any decisions last week. He's now come out and issued a ruling. And it's actually, well, we'll leave it there. We'll get into it in a minute and I'll explain what's going on. But we are seeing that Kari Lake and her team filed a request for relief from that order. So, trial scheduled tomorrow. A request for relief from the order that was just entered has been submitted. And so this is very important because this is articulating and detailing the rules for the trial as it proceeds tomorrow. So we got to go through this and understand it before we can make sense of the trial. Kari Lake hopped on. She's telling us that she's got 3 different whistleblowers, and there's this interesting new video going out where they're monitoring people at the signature verification centers here in the Arizona election 2022, and they're saying that this one person on the left is just flying through them, right? You can see approved, 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 whereas this person over here is actually matching the signatures. So we'll go through all of it, and you can see there are several different filings we'll take a look at. In addition, we'll look at Kari Lake's disclosure of witnesses because she has expert witnesses and she's got regular witnesses. And then we also have a court reporter who is being appointed, so we know trial. We'll be there tomorrow. We're getting ready for it. And so it's 9 a.m. my time is when trial is starting tomorrow. 9 a.m. Arizona time. It's very complicated for me to do math, so you guys can enter in your calculus calculators, get out your spreadsheets and do the conversions. I have no idea what they are. It's very complicated for me. Anyways, so that is what is in store for us. And if you want to be a part of the show, my friend, you can join us over at watchingthewatchers.locals.com. We do member-only streams just like this, except for members. Much smaller, a little bit more intimate. We'd love it if you joined us at watchingthewatchers.locals.com. We also have an after party when this show ends. We continue on for a bit. We'd love it if you joined us. And if you're joining us on YouTube, we got a ton of members in the chat. We're grateful to everybody who is in the chat. Come in and join us. Don't forget to grab the Telegram group link, which is where the chat never ends. The chat never ends. It goes on and on, my friends. So come and join us. And also, as we can see, we've got a lot of mind map nodes to get to today. And we can't do that unless we're properly fortified. And the best way to do that is to go to fieldofgreens.com, because we'd all like to lose those leftover pandemic pounds. But how sick are you of all the ads for weight loss pills and fad diets and all that stuff? We've all been there. We've all done that. We know they just don't work. But you know what does? Eating 5 healthy servings of fruits and vegetables every day. You do that, and the weight would probably just fall right off. But vegetables, not a fan. And fruit, who's got time to prepare that every day? It goes bad in like 2 days anyways. Let's talk about Field of Greens. Now, Field of Greens is a science-backed formula, very specific fruits and vegetables that you won't find in any other product, because proper nutrition reboots your metabolism so you burn calories faster and lose weight a healthier way. And Field of Greens is the only brand backed by a better health promise. Yes, you'll look and feel healthier fast, but the greater proof is going to come at your next checkup when your doctor takes one look at you and says, wow, you've lost weight. Whatever you're doing, keep it up. And so let's get you started. Go on over to fieldofgreens.com, load up your cart, and save 15% off your first order. It's real organic superfood at fieldofgreens.com, and you can save 15% when you use code Robert. And it's not just Field of Greens. It's lean products and stuff to help you sleep. They've got a whole different slew of things there, and the vegetables want to be eaten, so make the vegetables happy. Field of Greens makes me happy indeed. All right, and so let's get to it, my friends, because we've got business to attend to, and we're going to be starting off here with some Durham fallout news, because there was a lot of it, and we left off yesterday talking about it. Now that the Durham Report is out, many are wondering what happens next. The evidence seems to be obvious. The FBI opened a partisan and corrupt investigation into their political opponent, and they did it knowingly with intention. But will there be any consequences for it, or will they just keep getting away with all of this behavior right as 2024 looms? One Republican, Marjorie Taylor Greene, you see here, has taken action, filed articles of impeachment against the FBI director, Christopher Wray. And so we will take a look at those articles of impeachment. But this comes on the heels of the Durham investigation, where we learned that the FBI, along with the DOJ, were colluding to take out Trump. And so we're asking ourselves, is anybody doing anything about this? Marjorie Taylor Greene says, I am. Says, I just introduced articles of impeachment against FBI Director Christopher Wray. And under his watch, the FBI has intimidated, harassed, entrapped Americans who have been deemed enemies of the Biden regime. Says Wray, the director of the FBI, has turned the FBI into Joe Biden and Merrick Garland's personal police force. Christopher Wray needs to be impeached. And of course, this is a sentiment we've talked a lot about here, that the FBI has been weaponized to go after certain political opponents, spending all of their time on the J6ers, obsessed with Donald Trump from day one since he came down the elevators, and not focusing on anything else that isn't useful or that has utility for the Democrats and, or I would say, for the anti-conservative, anti-Republican, anti-communist efforts all throughout the country. We've seen it with many plots. The Whitmer plot, what I consider to be the J6 hoax. There was never an insurrection. And many other ordeals, including the Hunter Biden laptop cover-up and so on and so forth. They're supposed to be providing truth and justice and security for the domestic homeland. They are not doing that. And so what is going to happen, if anything? Well, Senator Hawley was also out after the report, and he explained that there should be prosecutions moving forward. He posted this on his Twitter account. He said Hillary and the Democrats tried to rig the 2016 presidential election, but weren't successful at it, and says there needs to be consequences. And what does that mean? We're always asking, what does that mean? What does it mean? Prosecutions, he says. Somebody being prosecuted. Now, the Republicans are not in charge of the Department of Justice right now. Merrick Garland is. And so is he going to prosecute his own people for being involved in bad conduct? Don't hold your breath.
No, we've got to get justice here, and justice needs to be served. You can't interfere in a presidential election without consequences. At least you couldn't. You used to not be able to in America. And that's what happened here. That's what this report shows, that one political party, the Democrats, tried to use the FBI to rig a presidential election and just about got away with it. They succeeded in getting the FBI to intervene. They succeeded in getting the FBI to lie to a court to get wiretaps. They succeeded in getting a presidential campaign, Donald Trump's campaign, spied on. I mean, it's amazing. If there's something like this in American history, I don't know what it is. And that's why I say there needs to be prosecutions, there needs to be accountability, and the FBI has got to be overhauled now top to bottom. It's got to be completely reformed. It cannot go on like it is.
So
no, we've got to get
prosecutions and total reform for the FBI, which I think is right on the mark. And he's talking about 2016. Of course, Donald Trump won that election in spite of the FBI's best efforts. They were literally colluding with Hillary Clinton's team through Michael Sussman and the rest of the lawyers over there at Perkins Coie, working its way up the chain, back up to Mark Elias to take out Trump. They posted stories on their Twitter timeline from Jake Sullivan. Jake Sullivan is now the national security advisor, all based on the false pretext and the premise of the Steele dossier, none of which was true. So we now have the House in Marjorie Taylor Greene, who says it's time to impeach. We have Hawley in the Senate, who says it's time for more consequences, political in terms of prosecutions and in terms of removal of the FBI authority in some way, shape, or form. Defunding them, reforming them, Congress taking action to reform the intelligence community. So we've got a little bit of agreement amongst the two houses, which is good news. Now, what about some people in the media? This one slipped through over on CNN. I don't know how they got this one through, but Jake Tapper had a very short moment of clarity and sobriety. Here's what he said about the Durham Report.
Regardless, the report is now here. It has dropped, and it might not have produced everything of what some Republicans hoped for. It is, regardless, devastating to the FBI.
Whoa.
And to a degree, it does exonerate Donald Trump.
Not to a degree there, Jake. Donald Trump is exonerated. Now, the refrain from the other side is, well, Russia, they still tried to connect with him, and that Don Jr. sat down and had the meeting and all of these other things. stuff that is absolutely trivial, they're latching onto to say that the crux of the investigation was justified when, as the Durham report revealed, as the Inspector General's report revealed, as we've been talking about here for years now, it had no basis at all. And so to hear that little 12 seconds from Jake is, whew, he probably got a talking to. They had to rewrite the entire teleprompter.
Regardless, the report is now here. It has dropped, and it might not have produced everything of what some Republicans hoped for.
Prosecutions,
It is, regardless, devastating to
Policy
the FBI.
changes.
And to a degree, it does exonerate Donald Trump.
Okay, so obviously Donald Trump is exonerated. He's been exonerated on this from the beginning. They colluded to spy on his campaign. They were very successful in it. And Jake Tapper says that's devastating to the FBI. Josh Hawley says there needs to be prosecutions. Marjorie Taylor Greene says there should be impeachments. What does the FBI say about this? Whew, they must be panicking in their boots. They must be shaken. Our agency is on the brink. We're going to get toppled any minute now. We're going to make some serious changes. We're going to respond to this. We're going to do better. We're sorry for what we've done, right? That's what they would say, right? No, no, not at all. They posted this on their official account. Statement on the report by Special Counsel John Durham. Didn't even give us a period. They say the conduct in 2016 and 2017 that Special Counsel Durham examined was the reason that current FBI leadership already implemented dozens of corrected actions, which have now been in place for some time. Okay, so leave us alone. Had those reforms been in place in 2016, the missteps identified in the report could have been prevented. Maybe if Trump would have put those reforms in place, all of this would have been avoided, or something, even though he wasn't the president. This report reinforces the importance of ensuring the FBI continues to do its work with the rigor, objectivity, and professionalism the American people deserve and rightly expect. In other words, we're not sorry at all. I don't see any contrition or remorse, not an apology. They said, actually, this report is exactly why we need more independence. We need more objectivity. We need to be more powerful so that we can work with more rigor and professionalism. It just supports what we've been saying this whole time. And had the reforms been in place in 2016, none of this would have happened. But we've already fixed everything. We're not sorry about it at all. And so leave us alone. They don't even care. All right, we're done. Stop bothering us with your stupid investigations. We're not changing anything. So after 316 pages from John Durham, we get one snarky paragraph from the FBI. And we don't care. Whatever. Let's leave us alone. We're good. And it's not ending there. This permeates throughout the rest of the agency. This is a clip of Andy McCabe, formerly at the FBI, courtesy of our friend Tom Elliott at Tom S. Elliott on Twitter. Great follow. He shared this. Andy McCabe hopped on with CNN to have a conversation with Anderson Cooper, who had a hysterical crying fit the other day. And he's back here in light of this damning report that came out from John Durham. 300 plus pages. Implicating the FBI, implicating this guy, Andy McCabe by name in particular, as being somebody who oversaw a lot of this, where all of the mistakes were made, where the partisan hackery was originating. 300 pages. Andy, do you have anything to say for yourself? I mean, we saw all the allegations about you and Strzok and everybody frothing at the mouth to go prosecute Trump, knowing there was no real basis in it. It's all been proven and vindicated. Everything you alleged was false. The FISA warrants all gotten fraudulently and so on. Would you like to apologize to the American people?
There's no new recommendations really in this report for the Justice Department
nothing.
about changing procedures. I mean, there have been a lot of changes at Justice based on the Inspector General's report back in 2019 and others.
Yeah, I'm not surprised at all because John Durham has failed to come up with anything new. Most of the report, the parts that I've been able to read in the last few hours, are a regurgitation of findings that were made by the Inspector General. Their attempt to justify two failed prosecutions that he brought against Igor Danchenko and Michael Sussman. There is nothing new here. And what he does present in the report, though, I will give him credit for this. He's entirely consistent with the prejudging of this investigation that he communicated, a month or so in starting it. We knew from the very beginning exactly what John Durham was going to conclude, and that's what we saw today. We knew from the very beginning this was never a legitimate investigation. This was a political errand to exact some sort of retribution on Donald Trump's perceived enemies in the FBI. That's what Mr. Durham has done.
And you stand by the original Russia investigation?
Absolutely. Absolutely. Listen, the mistakes with the Carter Page FISA were regrettable, should never have happened.
Okay.
And had I known about those mistakes in the packages, I never would have signed those applications. And shame on us for not knowing. But that's all business that the IG presented to America in 2019, 2019, I think.
Yeah, it was.
There's absolutely nothing new in this report. And I stand by the investigative decisions that we made to open the investigation first on the Trump campaign and the possibility that the Russians are trying to influence it, and then later on Donald Trump himself. And what did we find out from Special Counsel Mueller's investigation? The Russians did, in fact, influence the campaign. They wanted to. They tried repeated times. They had many, many contacts with the Trump campaign, and several of those people were indicted. So I guess what we were worried about all along actually happened.
Andrew McCabe, I appreciate it.
Andrew McCabe, well done here on CNN. So Andy McCabe is patting himself on the back. He's like, first of all, we got away with everything. No new criminal charges. Nobody on our side got indicted. Our side indicted a bunch of Trump people for a bunch of other reasons. And they're just cobbling together the little minor facts about any Russian. If Trump got an email from a Russian spam bot, they'd say, see, that's Russian influence. And they're just latching onto this stuff, disregarding the fact that we have 300 pages showing that these people were operating outside of the norms of other FBI procedures. We know that Hillary Clinton, when there were issues involving her campaign, she got defense briefings. They called her up. Hey, Hillary, we've got some issues with something coming up. Can you clarify this for us? Yeah, here's what it is. Oh, thanks. With Donald Trump, they said, oh my gosh, we got a spam email and a phone call from Igor Danchenko, who got subsources from Lord knows who gave it to Michael Steele. None of it was corroborated. It got emailed from Australia to somebody in the FBI, and they just opened up an investigation like it's totally legitimate. Like it was a direct phone call from Putin to Trump, and they're like, we're going to take over the world together. Because they were salivating. Look, it wasn't a mistake. This Carter Page FISA stuff wasn't a mistake. They're going to all hide behind plausible deniability. We can do better next time. We've made some reforms. It was all intentional. These people know what they're doing. They're not idiots. They knew that they needed to manufacture some allegation against Donald Trump because Hillary Clinton was falling from the rooftop because her email server was cleaned with a cloth. And she needed an alternative. She needed somewhere to point the media to get them off of her. So they created it and they fed it to Jake Sullivan, who posted it on Twitter. They did the same thing in 2020 with the Hunter Biden laptop letter. The intelligence community concocted up an alternative theory and they shoved it down everybody's throat, just like they did in October of 2016. So for Andy McCabe to sit here and tell us all that the FBI is reformed and regrettable and all the things, they're just liars. It's not true at all because their conduct has not improved from the beginning. But they are all still spiking the ball, very excited about it. Peter Strzok, you know him. He's one of the FBI lovers. This is the new game that we're playing. We have a new battlefield where it's whoever can capture the flag, which in this case is the Justice Department or the FBI or the CIA or the big tech companies. If you can capture the flag, then you can use those positions to go after your opponents and then take them out and then use them in a scoreboard. So that's what Peter Strzok is doing. Arguably one of the most at-fault individuals in this debacle, literally texting with his lover we're going to stop Trump. She said, will Trump be president? He's like, no, baby, you can trust me. I'm going to rig the whole thing. He's never going to win. Or something to that effect. Sends that message over to her. We will stop him. So these people are partisan hacks, but they captured the flag. They got the Justice Department to prosecute Trump's people. And when we had trials for Michael Sussman and Igor Danchenko, nothing there. DC juries acquitted them. Why? Because they were on Team Blue. Sussman was a blue team player. Igor Danchenko was a blue team player. These other people were not. And that's why they get convicted, because they are prosecuted out of DC where the cards are stacked against them. But they're spiking the ball. And this stuff is going to go well with their base. And when every time they say, well, Durham didn't conclude anybody did anything criminal, they're right, because he didn't. At least in his report, as far as we know now. And CNN is also very giddy about this. They're using this talking point that has been delivered to them on a silver platter. Says special counsel John Durham's report details his investigation of Hillary Clinton's campaign, and Durham concludes that he did not, all things considered, amount to a provable criminal offense. All right. And so the FBI is like, yeah, no, nothing. We didn't do anything wrong. It worked exactly. We sort of were beta testing it in 2016. We had no idea Trump was coming up. That's version 1.0. So we kind of got that one wrong, but we figured it out for 2020. Version 2.0 was great. And it worked. And we're not changing anything. Are you nuts? Because Donald Trump is running again. And there are hints, or there are discussions out there that there's more coming from Durham, or that there's classified appendices in the report that maybe Congress will review. We know that many people in Congress want to bring in John Durham to speak to Congress. Representative Jim Jordan has already invited him. We know Lindsey Graham has intimated that he wants Durham to come in and testify in front of the Senate. But the question is there anything else going to be coming from this Durham investigation? And it looks like the answer might, in fact, be no, because this was sent from Merrick Garland, the Attorney General who leads up the Department of Justice. Sent this on May 15th after the Durham report came out. He said, hi, Dick Durbin, Judiciary Committee Chairman over in the United States Senate. Hi, Jim Jordan, Committee on the Judiciary in the House. Also talking to Graham and Jerry Nadler. He says, hey, Congress, pursuant to the law, the same law that John Durham referenced in the opening of his letter, says, I write to inform you, here it is, that special counsel John Durham has concluded his investigation. Concluded. In addition to this notification, the special counsel regulations require that I provide you, Congress, with a description and an explanation of any instances in which the Attorney General, me, Merrick Garland, concluded that a proposed action by John Durham was so inappropriate or unwarranted that it should not be pursued. Did John Durham tell Merrick Garland something that Merrick Garland thinks is so inappropriate that it should not be pursued? If that happened, he needed to notify Congress about it so that Congress could be apprised that the special counsel is demanding something. So Durham could have said in this, theoretically, he could have said, well, my recommendation based on this report and based on my 4 years of investigating this is that the problems at the FBI are unfortunately systemic. They go to the top. It started with lower level agents like Peter Strzok, but worked its way all the way up to Andy McCabe. And there was a collusion, a coordinated effort to deny one particular candidate, something that was so rampant throughout all the levels of the agency that there's just no saving it. There's nothing we can do. Therefore, as special counsel, I recommend that Christopher Wray resign immediately. I recommend that prosecutions be initiated against the people who were part of this conspiracy, including Andy McCabe, including Peter Strzok, including Lisa Page, and everybody else. He could have done that, right? A whole list. Boom, 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 boom. Reforms. Anything involving other political candidates has to go through multiple step process or a litany of other solutions, anything. And Merrick Garland could have taken a look at the list and said, no way, that's inappropriate. That's unwarranted. I don't think we want to do that. We're not defunding the FBI. Are you nuts? we're not asking Christopher Wray to resign. Are you crazy? But if special counsel Durham recommended that, they'd have to apprise Congress of that. So Congress could say, wait a minute, what? He's saying he recommends defund the whole FBI? You're kidding me. But Garland says there were no recommendations that were inappropriate or unwarranted. In fact, there weren't any recommendations really at all. He says there were no such instances during Durham's investigation that were outside of pocket, in other words. Instead, he says on Friday, May 12th, consistent with Attorney General Barr's order, special counsel Durham submitted to me, that was on Friday, so he got to read the whole thing before it became public on Monday. Durham submitted a 306-page unclassified report in a form that will permit public dissemination, and we read through the executive summary of that yesterday. And there's also a 29-page classified appendix. Okay, so this is where we were reserving some judgment. Is there something else that is out there floating around? Is there something that Congress is going to latch into that's going to launch some other investigations? I don't know. There's 29 pages. It's a classified appendix. It's probably just an appendix with names and contact information and other things he doesn't want to put in the crux of the report, but you can leave open the possibility that maybe there's something else there, or maybe this will, initiate something that other entities in Congress can latch onto. In other words, John Durham spent 4 years investigating a bunch of stuff. He lays it all out on display like it's a giant buffet. He says, I can't make the connections here because of my position, because of my role, whatever his justifications are. But he wants Congress, the Oversight Committee. He wants the Judiciary Committee. He wants any other entity or even attorney generals from different states or whatever reason to latch onto this and go dine at the buffet and bring their own charges or bring their own actions. But on the face of the document, we don't see it there. The unclassified report and the classified appendix, so it's not an additional recommendation, it's literally just an appendix, are the only reports that Durham submitted to me. There's nothing else out there. Special counsel's unclassified report is attached as full, no additions, no redactions, no modifications. He says arrangement, Merrick Garland says, Congress, we will make arrangements for your review of the classified appendix. And finally, consistent with Attorney General Barr's order, I will disclose this letter, which we're reading now, and deliver it to the public. So that, to me, feels like that's pretty much it. Not sure that there's going to be anything else. Lindsey Graham, sure, they may drag him in front of Congress and have a conversation about this. Okay, but what are they going to do? Jim Jordan, yep, he's going to be very upset about this, ask a lot of questions, and it's going to be great for the American people to see it on display. But is anything going to happen? Don't know. Merrick Garland seems like he's putting a nice bow on it, and there's nothing else to come. But that doesn't mean nothing is happening elsewhere. As we mentioned at the start, with that background, we now see that Marjorie Taylor Greene submits her articles of impeachment, saying, if special counsel John Durham's not going to deliver any recommendations, that's okay with me. I've seen enough. It's time for Christopher Wray to go. These are the articles of impeachment submitted by Marjorie Taylor Greene, impeaching Christopher Asher Wray, director of the FBI, for facilitating the development of a federal police force to intimidate, harass, and entrap American citizens who are deemed enemies of the Biden regime. The ultra-MAGA extremist, the domestic homegrown violent insurrectionists. There's all sorts of different permutations. It's like those magnets you can put on a refrigerator. Insurrection magnets. Resolved, says Marjorie Taylor Greene, that Christopher Asher Wray, director of the FBI, is impeached for facilitating the development of a federal police force to harass everybody who's deemed enemies of the Biden regime, saying that these are going to be exhibited to the United States Senate. So we'll see what the House of Representatives does with this. And if they vote to impeach Christopher Wray, then it will go over to the Senate. She writes, articles of impeachment exhibited by the House of Representatives against Christopher Wray are submitted in maintenance and support of its impeachment against him for opposing America. Says the Constitution provides that the House of Representatives shall have the sole power of impeachment, and that the director of the FBI as a civil officer of the United States shall be removed only on impeachment or conviction for other high crimes. Green says, in his conduct as director of the FBI, in violation of his constitutional oath faithfully to execute the office and to preserve and protect and defend the Constitution of the United States, she says Christopher Wray continues to materially endanger the justice system of the United States and to empower Joe Biden to persecute his political adversaries at will. Article 1 of the impeachment document says, rather than adhering to an oath he took to defend and secure our country and uphold the Constitution when he was sworn in as the director of the FBI August 2nd, 2017, says Director Wray willingly refused to ensure that the laws passed by Congress and signed by the president are faithfully executed, saying that Wray has failed to uphold his oath and has instead overseen a denigration of the principles of our democratic republic by utilizing the FBI as a federal police force to punish or intimidate anyone who questions or opposes the regime. Says Director Wray has become a lackey of the Biden regime, persecuting the enemies of his handlers, including both public and private citizens, saying the FBI has taken unprecedented actions to this end. They conducted an unprecedented raid on the home of the 45th President of the United States, Donald J. Trump, on August 8th, 2022. FBI whistleblower named Garrett O'Boyle told congressional investigators that the FBI created a terrorist threat tag following the Dobbs Supreme Court decisions in 2022. The whistleblower, O'Boyle, confirmed that the purpose of the tag was to target pro-life individuals. On September 23rd, armed FBI agents in tactical gear raided the home of Mark Houck, a pro-life Catholic and father of 7 young children, allegedly because he obstructed access to an abortion clinic. We also know that former FBI special agent and federal whistleblower Kyle Seraphin obtained a leaked FBI document that targets traditional Latin Mass Catholics. The document was titled Racially or Ethnically Motivated Violent Extremists and Their Interests in Radical Traditionalist Catholics, RTCs, was reported out of the Richmond field office. This leaked document outlined a plan for the FBI to spy on Catholics, particularly those attending Latin Mass, who, according to the document, have white supremacy harbored in their souls, those Catholics. The FBI document indicated intentions to have informants within the Catholic Church. That came on advice of the Southern Poverty Law Center. These people have no shame, they have no limits, they have no borders, they have no decency. In October 2020, a group of men allegedly attempted to kidnap Governor Gretchen Whitmer in the fake Whitmer kidnapping plot. Several of the men were acquitted in their cases, including Brandon Caserta, as the FBI was found to have entrapped them in the scheme. Wonder how that happened, yeah. And most of the members involved in the plot were FBI informants. We covered that case here. A lot of similarities to January 6th. Again, warm up. That was 2016, version 1.0, 2020, version 2.0. Not only has Director Wray persecuted political opponents in an unprecedented and partisan way, but he's also overseen the agency, and his agency has taken actions to shield and protect Biden and his family. A senior FBI official left the agency under a cloud of accusations that he shielded a laptop belonging to the president's son, Robert Hunter Biden, from a criminal probe, protecting him, saying it's unacceptable for Director Wray or any civil officer to exercise his power in a way that targets one political class while doing favors for the other. Wherefore, given the aforementioned unprecedented actions taken by the FBI to subvert America, America and the people deserve a transparent justice system and law enforcement that keeps them safe and doesn't entrap them in serious criminal activity. That's why Christopher Wray merits impeachment. Wray, in his failure to uphold the oath that he has taken, lost the trust of the United States and citizens within it to execute the laws, saying his actions run counter to the steps that employees in the executive branch must take to avoid the appearance of the loss of impartiality, saying Wray has demonstrated he's going to remain a threat to the justice system. If allowed to remain in office, he's acted in a manner grossly incompatible with democracy, with self-governance, and the rule of law. Wherefore, Marjorie Taylor Greene says that Christopher Asher Wray thus warrants impeachment and trial, removal from office, and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. Articles of impeachment against Christopher Wray, documenting the long list, which is just a short list, much more could be added to this, about the FBI malfeasance in operations all around the country, and whether or not this leads to the impeachment of Christopher Wray. It starts the conversation about, so what? We have the Durham Report. We've got volumes of evidence that the FBI is highly problematic. They want to turn around and say the biggest threat to American democracy is white supremacy. It's behavior like this. It is elements within our government that are going to be undermining our democracy from within the government. They need to be held accountable and rooted out. If they're acting in partisan manners, that is undermining the Constitution. It is not equal protection of the law when the FBI is using the law unequally. So this resolution is now going to provide an opportunity for other Republicans who talk all day long to draw a line in the sand. Are they going to join in on this? How are they voting in the House? Because this is a clear action that is being done. Or they can just sit around and complain for the next 2 years while Joe Biden and the FBI continue to concoct another scheme for 2024. So Marjorie Taylor Greene is doing something. We'll see where it goes, and we'll see who on the right joins her. Okay, my friends. Now, that was Marjorie Taylor Greene and the Articles of Impeachment. FBI is just not even concerned at all. They think they did a great job. Life's good. And so, of course, we will continue to cover this. We'll see if other Republicans join in. Thank you for subscribing wherever it is you're watching this. Thank you for joining us. And now it's time to go to trial prep, my friends, because we've got some business to attend to starting bright and early tomorrow. Kari Lake and her legal team are in the final hours of preparing for a new trial on count 3. This is the issue regarding signature verification and really whether Maricopa County complied with Arizona law. We've got several documents that are necessary to review before the trial starts, including the judge's ruling that was taken under advisement during the last hearing, because everything we're about to look at explains the rules for this trial and it details what Kari Lake's team has to prove. We've got several different things to dig into. The under advisement ruling came after the judge heard evidence last week, and we put a pause on that. The judge wrote the opinion, and this is what we're going to spend the bulk of our time on. But I wanted to just give us some context because the ruling came out, and immediately Kari Lake's team filed a request from the ruling. So we got to go through both of these documents simultaneously. They're going to be the first one. These are going to be the first issues that they deal with before the trial starts. We also have new disclosures from Kari Lake's experts, her expert witness, as well as her other witnesses. And we've got a court order for a court reporter to be there scheduled tomorrow, which means it looks like the trial is in fact going to be on and moving forward, which is good news. Kari Lake was talking about this This clip came over from Patriots Are in Control. Says Kari Lake is going to trial this morning, and said Kari Lake is going to trial tomorrow. Kari Lake showed up on the Steve Bannon show, War Room podcast, and explained her position and what her team has uncovered.
Well, this is an absolute huge victory for election integrity, Steve. For the past few years, as we've talked about, signature verification has been that third rail in Maricopa County. You can't touch it. You can't talk about it. And that was really the line in the sand that the county drew during the Arizona audit. And it's not difficult to see why they don't want us looking at those signatures, because guess what? They don't match. So this challenge is not simply about a few bad signatures. We are prepared to show the systemic failure of the entire signature verification process, the only way we have security on those mail-in ballots, by the way, and it's a complete joke. And I know, we're old enough to remember the Carter Baker report, Steve. It wasn't that long ago when even the Democrats benefited mail-in voting as one of the greatest potential sources of fraud, because it opens up the chain of custody to malicious activity. And that's what we saw in this election. So signature verification is one of the only methods to verify that a mail-in ballot would be authentic. And the process we have in Maricopa County is a complete sham. They're not following the law at all.
So I want to pause real quickly to explain what we're watching on this screen. And this evidently came from the America Project. And they've got this video where two people look to be at a signature matching center. And this person on the right is taking his time or her time matching the signatures. Something pops up on the screen. They take a look at the two boxes. It matches, moves on. And in order to do that, you got to actually take a look at the signatures, right? You can't just hit yes, 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 yes on every one. So we have that one being tabulated in the green over this area. And then this person over here is just motoring through the signatures. You can see this one is just almost pressing a button, match, 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 match. So what we're seeing is something that looks like signature verification is being done technically, because they're flying through a bunch of signatures, if this is what it purports to be. And that's going to look like evidence of signature verification, right? But is it really signature verification if you're not doing any signature verification? It's like, yeah, I checked all the things, but I didn't really check all the things. I just marked I checked the things. Here you can watch it as Kari Lake continues to explain.
So my team and I, we've identified 3 whistleblowers who were intimately involved in the signature verification process in Maricopa County. They speak of how they were rejecting tens of thousands of signatures, up to the tune of maybe 130,000 ballots. And then somewhere above them in the chain of command, they were just being sent on through. Those ballots were being sent through anyway. And you should see some of these signatures. It's like a chicken scratch. Scrawls. It's an absolute joke. Doesn't even match the voters' signature.
So did you see that? It was 48-6 by the time we started this one here. 48-6. And that's, again, presuming that these people are doing the same job, doing the same task. This is part of the same center. And if you recall, back during the Arizona election, we were poking around and watching the various camera angles from within MCTEC, which is the Maricopa County Tabulation Election Center thing. And they had people in bullpens and set up in different locations, different vicinities. And there was an assembly line, right? They'd come in, one group would do one action, then it would escalate if there needed to be another set of eyes on it. We had fill in the bubble challenges. We had two different parties, and they would stand over you and they would adjudicate the ballots. And so the list goes on and on. But this looks like a pretty different pace, right?
It doesn't even match the voter's signature. It's a willful violation of the law, and we're not going to sit here and take it anymore. So we're going to prove this. These mismatched signatures, they were added to the final count. They should have been tossed out completely. Our whistleblowers, Steve, are going to be exposing the process for what it's worth and what it is. It's a complete sham. It's a lie. It's Maricopa County's way of injecting hundreds of thousands of bad ballots into the system. And we're confident that the number of fraudulent ballots exceeds the 17,000 margin separating myself and Katie Hobbs in their count of the election. And this is just the tip of the iceberg.
Okay, so we are now going to dig into that. Now with that backdrop, we remember that we left off with oral arguments and evidence being presented to the court about what counts can move forward for the trial. The way that this worked, Kari Lake had a trial, lost, appealed this, and said, hey, wait a minute. One of the counts that I should have had trial on, that I couldn't have trial on, is count 3, which is the signature verification issue. And so it went all the way up to the Court of Appeals, then to the Supreme Court of Arizona. They said, you know what? You're right. You should have had trial on count 3. You didn't. So we're going to send that all the way back down, do it again. And when that came back down, Kari Lake's team said, oh, well, this is great. We also want to bring back count 2, and I think it was count 7, that they also wanted to say, hey, we've got new evidence now, Your Honor. This was dishonesty on the stand, and so we want to present new evidence. Katie Hobbs and the government, they wanted the opposite. While Kari Lake wanted to move forward on count 3 plus other charges, Katie Hobbs said, well, now that we've got new evidence, we don't even think we should move forward on count 3. And they submitted a new motion to dismiss count 3 in addition to the other counts. And so we were waiting for this opinion to come from the judge. What is he going to do? There was the possibility that he could dismiss and grant Katie Hobbs's motion, dismiss everything. There's also the option that he could have come back and granted additional counts, meaning Kari Lake could have gone maybe on count 2 and maybe count 6 too. And we didn't know. And we were all waiting on pins and needles to see, including people wondering if the trial would be moving forward at all. If Katie Hobbs got her way and her ruling would have been granted, we may not have seen anything move forward. But obviously that did not happen. We do have the under advisement ruling from the judge. And here's what it looks like. This was filed May 15th, 7:30 p.m. Many of us were waiting around going, where's the filing? We've got trial coming up. It hit the docket late. And we'll see why. It's 8 pages and it's got some heavy lifting in there. The court said the following, says we have considered the filings of the parties now. Governor Hobbs renewed her motion to dismiss everything. And we've also considered Kari Lake's motion, and she wants to bring back additional counts. And says, I've considered what everybody wants, and here's my decision. Says this case in front of us came back down from the Arizona Supreme Court, as we explained. This court dismissed a bunch of other counts, and the Supreme Court said, good call. You should have dismissed those. Those were affirmed. But count 3 was dismissed on the ground of latches, saying, hey, Kari Lake, you can't complain about signatures after the election. If you had a problem with the signature verification process, you should have brought it before the election. You brought it after the election. Latches bar you from bringing a claim that you should have brought before or after, and therefore dismissed. But the Supreme Court said, hang on a minute, she can't complain about a bad signature verification process until after the election when she learns about it. And so you do have to hear some evidence on this case, and they remanded it back down to the lower level court, which is where we're at now. The court said the following on remand. This is what Arizona Supreme Court said when they sent it back. They said, it is further ordered remanding to the trial court to determine whether the claim that Maricopa County failed to comply with the law fails to state a claim for reasons other than latches. All right. So if the court takes a look at Kari Lake's claims again and says, well, look, if we get rid of this latches thing and there's still no other reason that she can state a claim, maybe we could dismiss it again. Says petitioner, or whether petitioner Kari Lake can prove her claim and establish the following, right? This is the order, the remand from the Supremes. Or whether she can prove, so she's got to meet one of these two standards. Whether votes were affected in sufficient numbers to alter the outcome of the election, based on a following standard, competent mathematical basis to conclude that the outcome would plausibly have been different, not an untethered assertion of uncertainty. Okay, so these are like tests that we see in the law. A great way to think about this is like DUIs, right? You have a DUI, you have a blood alcohol limit, it's 0.08 and above, okay? That's the standard. If you're 0.08 and above, you're over the legal limit. We set that as a scientific standard that we measure, they allege scientifically, if you believe that, and then they give you a result. So we're understanding what checkboxes the government needs to hit in order to convict you. They've got to prove that element. Similar thing with standards in the processing of cases in criminal court. You've heard of the standard, beyond a reasonable doubt. You've heard of the standard, preponderance of the evidence and clear and convincing evidence, and these different standards. These are the rules that we use. These are the mechanics of the board game. And so the judge, as we talked about in the first trial, is very clear about what these are. And Kari Lake and her team, they have to hit these things. And the judge is detailed on this, okay? Literally. Competent mathematical basis, meaning we better have some formulas. And the outcome would have plausibly been different. And the numbers have to be sufficient to cross the margin. So we're going to see if we can get there. It says, with all of that in mind, now the lower level court is saying, I've got the rules on how to handle this for this upcoming trial. Here's what I decided. The court will grant a motion to dismiss based on Kari Lake's failure to state a claim when, as a matter of law, this is a rule, this is not what the judge is doing, they will dismiss it if they're not entitled to relief under any interpretation of the facts. So if we look at everything that Kari Lake alleges in a light most favorable to her, and she still can't win, if we say you're right about everything and you still can't win, you got to get dismissed. In determining whether a complaint states a claim, the court must assume that all well-pled allegations are true and indulge any of those reasonable inferences. And saying that you only need to provide a short and plain statement of the claim in order to meet that standard. The government is saying that Kari Lake doesn't meet that, obviously. They raise problems with count 3, which is the signature count. And they say there are 3 problems with them in 3 areas. They say that the form of these allegations is problematic. But we're going to waive that, saying you guys can't raise that now. Sorry, you didn't raise it at the lower level court, so the government is precluded from raising this issue. Says similarly, Katie Hobbs also argues that Lake fails to allege that any specific mail-in ballots were illegally counted. But that argument also fails too, because Arizona is just a notice pleading state. Says that in her response, Kari Lake concedes she's not contesting the signature verification process for specific ballots. Lake now clarifies for the first time that under the widest possible reading of count 3, Lake is contending that election officials failed to comply with the Arizona election manual and the election law, listen to this, by not performing any, and the judge put this in capital letters, did not perform any steps to comply with level 2 or level 3 screening or notification of electors to cure ballots where level 1 screeners found signatures were inconsistent. So the judge has taken Kari Lake's argument and has essentially reinterpreted it and said, here's what Kari Lake is alleging. There were zero, not one, literally zero, not performing any steps to comply with level 2 or level 3 screening and didn't notify any. Lake argues those ballots were counted in sufficient numbers to affect the outcome of the election. And I'm not sure this is exactly what Kari Lake is arguing, which is my point here. Is that what they're saying? That they didn't do any level 2 or level 3s? I'm not sure that's right. I think that they're saying level 2 and level 3 were problematic. Let's continue on. Says, while the wording of count 3 does not state this allegation clearly, it's Kari Lake's allegation in count 3, it can be read broadly enough that Lake's argument fits under notice pleading requirements. The response and oral argument have further narrowed this claim sufficient for Hobbs to be on notice as to what violation Lake is arguing. So Kari Lake has said, you did something bad. We're trying to interpret what that thing that is bad is, and then specifically have to articulate it so that we can organize it into checkboxes that the law allows us to pursue. The second area the defendant's Hobbs attacks is the lack of sufficiency of Kari Lake's allegations. Maricopa County makes the compelling argument, says the judge, that Lake's challenge to signatures on mail-in ballots seeks relief beyond what the legislature has provided. Simply put, the county argues that because a party representative can challenge a ballot signature reconciliation as it's taking place, in other words, you can challenge the signatures right then and there, but you can't after the fact. The legislature has provided an exclusive remedy for what Lake is arguing. The judge says, well, it's true where the legislature has provided for a right. Says the court has agreed with the county that the legislature, the law does limit Kari Lake's recourse for challenging individual signatures. Otherwise, it would completely cripple the election system. So the judge is saying Kari Lake can't go in there and look at every signature one by one. Otherwise, it would cripple the process. But this relief at the level of individual ballots does not preclude a claim that the county recorder failed entirely, once again, here it is, to perform any level 2 or level 3 signature verification on the ballots where level 1 found that the similar signatures didn't exist. So again, you see this, the judge is giving Katie Hobbs a framework. If they can just come in and show, oh yeah, no, we did level 1 and we did level 2 and we did level 3, then that's necessarily, the judge is going to say that is going to disprove Kari Lake's complaint, because the judge is interpreting Kari Lake's complaint as saying you didn't do level 2 or level 3. And we're going to see if Kari Lake's lawyers correct that. Is that what they're actually alleging in their complaint? Judge says this is in sharp contrast to an allegation that the Maricopa County recorder or designee improperly exercised his or her discretion within the policy. All right. So now we're seeing the judge separate these things out. It's not about whether somebody is tapping the keys, approve, 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 approve. There's discretion. They have some subjectivity. They can decide whether these things match or don't. And that's not what's at issue. We're not challenging the accuracy of the signature match. The judge is saying Kari Lake is making the argument that they didn't do the signature match at all. And that's what she's got to prove. Additionally, the governor argues that it is now simply too late to litigate count 3 because she's been in office for 5 months. We already captured the flag. You can't take us out anymore. But the judge says, sorry, the law says no time limit on this. Assuming all of the other requirements are met, the court may grant relief. Says the statute, yeah, it's true. The statute as written does not appear to take into consideration the fulsome appeals process. The statute's not really great on this. But subsection C states that if the court determines that a person other than the contestee has the highest number of legal votes, the court shall declare that person elected and further nullify the certificate of the election of the person whose office is contested. So the court can just declare Kari Lake the new governor if that is what the court determines, and nullify the election of Katie Hobbs. That's a big ask. We'll see what this judge does. Now, the court sees no requirement that appeal and remand take place over a certain period of time, and they can't read that in there. So just because she's been in office for 5 months doesn't matter. Now, in the second area, the government argues that because Lake does not simultaneously allege both misconduct and illegal votes, that she cannot prevail. But judge says, I don't buy that either. If Maricopa County is right, any challenger would be required to double up. And so the court says, we have read the statute as providing 5 reasons why anybody might seek relief. It may have been more prudent to allege more than one ground for each of the set of facts that Lake brings into her complaint. In other words, Kari Lake's complaint could have been fortified a bit. But the court is not going to dismiss on the grounds that her failure to do so leaves the defense lacking notice. It's good enough to survive the dismissal. but it's going to be a hard thing to prove in court, is basically where the judge is going. Indeed, her complaint at paragraph 151 specifically notes, and so remember, Kari Lake is alleging these things happen. So the judge is saying, okay, you said they punched you in the face. Well, you got to show us the punch. You got to show us these things. And so he's going back to her complaint. He says, it says, paragraph 151 says, to be lawful and eligible for tabulation, the signature on the affidavit accompanying an early ballot must match a signature featured on the elector's registration record. It says, there you go. That's sufficient to put Maricopa County on notice of her objections. That's all you need. And the third and last area focuses on completeness. Katie Hobbs objects. She says, Kari Lake has not stated exactly how many ballots were improperly admitted, but judge says she's not required to do that in her complaint. Arizona is notice pleading, and the court finds that while she must raise the nature of the violation, she does not need to plead the precise number of ballots. In other words, Katie Hobbs is saying, hold on a minute. Kari Lake needed to basically prove everything in her complaint, tell us how many numbers, where the violations were, all of it. The judge says that's not required here. She just has to tell you the notice, what is the claim about, and then she can fill in the gaps later, but it doesn't need to be in the original complaint. Put another way, judge says Lake must prove a competent mathematical basis to win at trial, but she doesn't need to put that in her complaint at the start of the trial. Lastly, the judge writes, here, Katie Hobbs and her side also argues these claims are based on reports and allegations from 2020. Says this is an evidentiary argument for trial rather than a basis to dismiss. Any opinions based on 2020 must also be proven in trial and also must have an adequate foundation and be reliable, just like any other opinions that come in. So the judge is going through one by one and taking out Katie Hobbs' objections, but also in doing so, interpreting Kari Lake's complaint and her claims and showing that she's got some heavy lifting to do. Judge continues saying, in her response and at oral argument, Kari Lake conceded, said the following, she is not challenging the process of signature review as to any specific ballot, whether any given signature matches a voter record or that the process was effective, not challenging that. This is the judge's interpretation. She is instead alleging misconduct by the Maricopa County defendants, here it is, through a wholesale failure at the higher tier signature verification process to reconcile non-conforming signatures or to cure signatures pursuant to the law. She alleges, Kari Lake, that Maricopa entirely failed to perform the signature matching required by the law. So that anybody in level 1 who had a problem that took it to level 2, they're saying that didn't happen. The judge is saying that is Kari Lake's argument, which is a high standard. That's kind of a problem for Kari Lake, because if the government comes back and they say, no, we have one person who looked at one challenge at level 2. That's it. That's the game, according to the judge's interpretation. As Lake put it in her response, she brings a Reyes claims, not a McEwen claim. She challenged Maricopa's failure to act, not its action on a particular ballot. So the judge says, taking Lake's concession, she gave up some ground. She's not challenging ballots. She's challenging the failure to even process the ballots. She has stated a claim. It's a tough claim to state, but man, it's a claim. The judge says, as was said in the court's order on December 19, 2022, whether Maricopa County complied with the election manual and the various statutes governing the elections is a question of fact. Lake has narrowed her claim. We talk a lot about hula hoops here, got very narrowed. And this is what the judge says. Kari Lake must demonstrate at trial, pursuant to her concessions, that Maricopa County's higher level signature reviewers conducted no signature verification or curing, and in doing so, had systematically failed to materially comply with the law. And he underlined that. I covered it up, but he said no. They conducted no with underlines. No signature verification or curing. That's what the judge says she's got to prove. So if they come back with one, that is not no. This is, of course, which is a tall complaint. This is, of course, in addition to the requirement that she prove that this alleged complete failure to conduct signature verification resulted in a change in the outcome of the election as proven by competent mathematical basis. And all of this must be done by clear and convincing evidence, which is not preponderance of the evidence. It's higher than that, but it's lower than beyond a reasonable doubt. Clear and convincing. So all of this must be done, which means Kari Lake is not making a half-court shot. Kari Lake is making a full-court shot while she's balancing on a balancing beam, fighting off a grizzly bear. She's got to swish it, dunk it in. Very high standards. Because if the government comes back and they just say, no, obviously we did level 2 signature verification, then that's basically it. Now, Kari Lake's team is going to challenge this, we think. They challenged it today. We're going to read their motion next. But as we see, the renewed motions to dismiss as to count 3 are denied. So Kari Lake moves forward on count 3. Now, Kari Lake also filed a motion. She wanted to bring back other counts. She wanted to bring back counts 2, 5, and 6, saying we discovered new evidence and that Arizona rules say that if you find that there was a fraud committed on the court, you can bring back other counts. The judge says, well, I heard your arguments. Now, to the extent that the civil rules can apply to an election challenge, they do. This includes Rule 60. The court's not going to rehash arguments going back to my prior motion to dismiss. The judge says, though, while admittedly election challenge statutes do not show a great deal of consideration for post-trial rules like can you reopen a claim, had the legislature wanted to accelerate this, they would have done so. However, the merits of the motion are another matter. So, Kari Lake, you can file this. I'll listen to it, but I've considered it, and I don't think it's good. The dismiss count 2 alleged that the ballot on demand printers in count 2, Kari Lake's words, the printers involve tabulator problems. They're not certified and had vulnerabilities. The judge says Lake attempts to rescue this count by arguing that evidence now shows that Maricopa County reinstalled software on memory cards used in the ballot tabulators without performing logic and accuracy testing. Oh, man. So her complaint talked about printers in count 2, but the new evidence shows about the tabulators. Oh, man. So it's a technicality. Oh. Assuming this evidence could not have been discovered before trial, it goes to a completely different set of election day processes than were alleged in count 2. Suggesting that the tabulators were maliciously configured to not read ballots is different from alleging the printers could not write the ballots. The time to amend a complaint is before the matter goes to trial, not after. Sorry, Kari. In fact, the law does not permit amendments of complaints at any time. And so while the difference between a tabulator-based claim and a printer-based claim may seem like it's just a subtle distinction, and this judge is just splitting hairs, he says it's not. Count 2 was fully litigated at trial, and this court's disposition was affirmed by the Court of Appeals and the Arizona Supreme Court. This is not newly discovered evidence that goes to the claim as presented in the court and reviewed. It's a wholly new claim, and therefore, count 2 remains unrevived. So can she file a new complaint and make that allegation now or not because she's time barred? Lake also takes issue with the testimony of Scott Jarrett, who testified that the voting center difficulties faced on election day were just minor, not a big deal. Lake, needless to say, disagrees and offers additional evidence to attempt to demonstrate fraud or misconduct. Lake took this same position at trial and even recalled Scott Jarrett during her case. But evidence that is merely cumulative would not have changed the result and is not enough to revive a claim. Mere contradiction is not enough to prevail on grounds of fraud or misrepresentation. The judge continues, saying the allegation of fraud also leaps over a substantial gap in the evidence. The court notes that Lake's representation of what McGregor report would show is 180 degrees different from what the report actually says. Whoa. Rather than demonstrating that Mr. Jarrett lied, it actually supports his contention that the machine error of the tabulators was mechanical and not tied to malfeasance or misfeasance. At trial, Kari Lake presented the purely technical evaluation of Clay Parikh, which found that the only possible cause of malfunctions on election day could be willful and intentional systemic manipulation to create the errors. However, those conclusions were undermined completely by the very next witness at trial, David Betancourt. The testimony of Mr. Betancourt, who was called by Kari Lake, was summarized previously. They said Kari Lake's other witness testified that there were, in fact, multiple technical issues experienced on election day. He testified, this was the election worker guy. He said he testified that there were problems. They took out the toner and the ink cartridges. They shook them like everybody does. They cleaned out the corona wire. They just let the printers warmed up. They cleaned out the tabulators. They adjusted the settings of the printer. They probably banged it on the side. Work! It is of note, apart from 5, none of these solutions implicates the ballot in a manner suggesting intent. Mr. Betancourt testified that each of these on-site actions were successful, with shaking the toner cartridge being the most effective. The judge says it's worth repeating that ballots that could not be read went into door 3 where they were counted later. They also say that Betancourt testified not only did he lack knowledge of any tech engaging in misconduct, but further testified everybody worked hard to fix the problem in a frenetic election day environment. So they say, Kari Lake, your own witnesses testified that the printer failures were mechanical failure. So the judge says not good enough. Months after extensive review, testing, and evaluation, the report by former Arizona Supreme Court Judge Ruth McGregor came to the same conclusions. But now Kari Lake seeks to allege fraud based upon the same type of purely technical evaluations presented at trial. This isn't evidence of fraud, but additional evidence offered to support the view that error codes can prove intent or state of mind. The court is not required to accept that premise. And saying, ignoring the defendant's view, even Mr. Parikh conceded that ballots which were not read were transposed and counted. The court notes that counsel's representation in the motion, saying that 8,000 ballots were not counted, is not supported by the declaration. The oral arguments presented clarified that error codes do not respond to votes not counted, and so counsel cannot ask for a gap in proof with unsupported assertions. And so finally, the court notes with respect to Lake's request to reconsider, the motion does not grapple at all with the reason the court dismissed those claims previously. These counts are simply bootstrapped to constitutional arguments. And so reconsideration of them is not warranted. This is a claim that's already been fully litigated. The evidence presented falls far below what's needed to establish a basis for fraud. It is important to remember, this is an election challenge. Focus is on how votes affected the election, not a basis for relitigating prior claims. So the judge concludes, he says, it is therefore ordered denying Kari Lake's motion to bring in additional counts. Trial dates are reaffirmed starting tomorrow, noon Eastern time. On this channel, we'll be covering it live. It is further ordered denying the motion from the amicus. The amici attorney is not going to be able to submit his brief. It's basically a refiling. They've already been ruled upon. So that is the order from the court. Now, this sets a very high standard for Kari Lake, and the judge was very clear about what she's got to meet. 2 things. 1, 0, literal 0 signature verification or curing at level 2 or level 3, and that action was enough to change in clear and convincing evidence, meaning it's going to be a tall order. Now, there were some questions about this. Is the judge properly interpreting this? Is he really getting Kari Lake's argument right? We see that there was a response. Kari Lake submitted this one right away, bright and early in the morning. As soon as that opinion hit, we saw that one dropped at 7:30 p.m. on the 15th. This one dropped 6:46 on the 16th a.m., which means Kari Lake's lawyers were up working feverishly to get this out the door. It's 35 pages, several different exhibits attached. Let's see what they're asking for. They say, hey, Judge, we just got your order that says we got to do a bunch of stuff. We're not happy about it. And so we hereby move from relief from the judgment on what you just wrote. It says, pursuant to the rules, the court issued an order dated May 15th, limiting Kari Lake's claims on count 3 to violations only at levels 2 and 3 of Maricopa's signature verification process. Specifically, the court held that Kari Lake alleged that only Maricopa failed to perform any steps to comply with level 2 or level 3 screening or notification of electors to cure where ballot 1 were inconsistent. He's referencing the order. The court held that Lake has narrowed her claims. He's going to say, no, he didn't. As discussed below, our complaint pleads violations at all levels of signature verification, not just levels 2 and 3. In addition, our expert, Eric Speakin, cited data that came from Maricopa County pursuant to a public request as one of the bases for his expert opinions. That data consists of 1.4 million records relating timestamp log data about Maricopa's signature verification in 2022. Continued analysis of this complex timestamp log since May 12th revealed information relevant to his opinions. This data does not add another expert opinion, does not change his previously disclosed opinion, does not identify a new basis for this. But says Spekin has continued to analyze voluminous data for information relevant to his previously disclosed opinions. This data shows the following. There were 700,000 instances where evaluation of the signature was made in less than or equal to 5 seconds per signature verification. There were 600,000 that took 4 seconds or less. There were 465,000 that took 3 seconds or less, 274,000 that took 2 seconds or less, and there was 70,000 instances where the signature verification was made in 1 second or less. 700,000. Boom, match. Match. 1001, match. And match. And matches. And matches. And on. Spekin's opinion said that signature verification was either not performed at all, including at level 1, or was simply clicking through the images without conducting a signature verification in any manner. Remains unchanged. And as discussed below, this new evidence warrants relief from the order under the rules to allow Kari Lake to show evidence that certain level 1 signature verification workers are also violating the law, as alleged in the complaint. He's saying, Your Honor, that does match. I was talking about all signatures, not level 2 and level 3. And simply clicking through hundreds of thousands of signatures without conducting any verification is inappropriate. So Lake seeks relief from your order based on mistake and new evidence produced by Maricopa in the form of timestamp logs for all level of signature verification workers. She also seeks relief under a catch-all for other reasons justifying relief under ARCP 60B6. Says Rule 60A allows the following. The court held that Kari Lake alleged that only Maricopa failed to perform any steps to comply with level 2 or level 3. However, Kari Lake complaint pleads violations at all levels, level 1 as well as level 2 and level 3. And he's referencing this. He's saying, we already said that, incorporating the foregoing paragraphs as set previously. So judge, don't limit us to only level 2 and 3. In addition, Kari Lake's complaint pleads a consistent factual basis for the court to find misconduct with respect to levels 1, 2, and 3. And that 130,000 ballots would fail as egregious mismatches, and another 167,000 would fail the signature verification process. That's a total of almost 300,000 ballots that should have been rejected in the figure. Says that Kari Lake also cited the same information in other motions. In short, the plain language of the complaint does not limit plaintiff's claims to levels 2 and 3, nor did Kari Lake argue anything different in her opposition. So this judge is very narrowly interpreting their complaint, and they are asking the judge to open this back up because they realize if they're only limited to proving 0 signature verifications took place at level 2 and 3, that's very different than their argument, which is, as we're seeing now, that the signature verification process was not done appropriately. The judge says, you're not complaining about the process, you're complaining about whether it was done or not. They're saying, no, we're not. We're complaining about the process. New evidence produced by Maricopa, this is Kari Lake's team, they say, this also warrants relief from the order. Your prior order. We need to argue a much broader scope tomorrow. Motions for relief from orders on newly discovered evidence must meet 3 criteria. The newly discovered evidence could not have been discovered before the judgment. The evidence would probably result and change the result of the litigation, and the newly discovered evidence was in existence at the time of the judgment. Here, new evidence produced by Maricopa County, called PRR number 1482, relates to complex, voluminous timestamp log data for all of Maricopa County's signature verification workers employed during the election. Maricopa did not produce this data until April 26, and we didn't get it for our expert until May 12th, just a few days ago. As set forth in greater detail, this information relates to information that Maricopa produced in response to a record request that came in from We the People AZ. The data sought, among other things, timestamp log data and everything conducted for levels 1, 2, and 3 during the election. Hansel had to engage in numerous discussions with Maricopa. They repeatedly delayed producing the data set to Kari Lake's expert. You're kidding. Though Maricopa finally provided a voluminous data file consisting of 1.4 million records, it was not until May 4th that Hansel received the information. The data was taken and has taken significant time to review. We finally got it reviewed, and we submitted our expert disclosure by 5 p.m. Friday. We saw that. Specken was not able to fully analyze the timestamp log data produced before, and he's continuing to analyze this data as he prepares opinions for trial. Kari Lake previously disclosed the existence of this data, and Maricopa is also the producer of this information, which it has control of. Aware of the nature of this data, so our supplemental disclosure is not going to prejudice them since we got the data from them. They know what they have. And says also, Your Honor, generally, there's another catch-all provision that allows us to get this hula hoop reopened again. Allow us to broadly argue signature problems. Arizona's jurisprudence does provide some provisions. Here, the circumstances described above are equitable reasons to justify relief limiting evidence to levels 2 and 3. So unfortunately, this is kind of the last ditch rule. Anytime you're digging into a catch-all provision to drag something out to say, can you just give us relief because it's the right thing to do? Can you just, judge, it's the right thing to do? You know what we're trying to argue. If you interpret the language to narrow it down to make it only about whether any level 2 or 3 was done, you're going to make us lose. You know that. And we have all sorts of other evidence here, including everything we just detailed, to show you that the signature verification process was problematic, not whether they did it or not. And so they're asking for the mercy of the court, in other words. Equitable reasons. Just please be fair. and let us make these arguments. Don't limit the evidence to levels 2 and 3. Says the timing of this motion is reasonable, and for the foregoing reasons, we respectfully request this court grant Kari Lake relief from the order limiting her claims exclusively to levels 2 and 3, and also allow the inclusion of the timestamp log data referenced previously. And they're detailing the other order there. Actually, this is the order that they are proposing the judge signs. Said, on consideration of Kari Lake's motion, the court finds the motion and the order is granted. This is what they want the judge to sign. They want the judge to sign this. They're preparing it for the judge. They're saying they want count 3 to include allegations of ARS by level 1 may be used in his expert opinion. So the judge is going to rule on this very likely first thing in the morning, and I'm not optimistic about it. He's already issued his ruling under advisement. To get him to change that is going to be a different thing. And so we'll see if he allows Kari Lake and her team to make those arguments. So the game might change a bit. Kari Lake has witnesses that she is prepared to call, but if those witnesses are only useful to show that level 1 signature violations were problematic, the judge says he doesn't care about that. He only cares about whether they went up to 2 or 3. And he doesn't care about whether 2 and 3 were good or not, whether they were legitimately done, just whether they happened. And if they happened, it sounds like he's going to say Kari Lake's complaint fails. So Kari Lake is bringing in other witnesses. This was her disclosure about the expert witnesses who are going to be testifying if this moves forward. Eric Speakin, he is an expert who's going to comment and respond to opinions and other experts proffered by their witnesses. He's got a lot of education and a lot of experience. Let's take a look at some of it. Eric Speakin, who we are likely to hear from very soon. Forensic document analyst, ink dating specialist, worked at a forensic laboratory, went to Purdue University at age 15. Wow. Smart young man. Multiple publications about chemical removal of magic marker on photocopied documents in 1995. Look at all these documents. Invited speakers all over the place. He's going to be one of Kari Lake's witnesses. Been appointed by judges in 30 states to do investigations and so on. So he'll be somebody we hear from. We've got other witnesses coming in. This is Kari Lake's disclosure of the other witnesses who will be at trial, and we've got several of them. Trial is starting May 17th, 18th, and 19th. We are going to be covering it live. We've got Eric Speakin, Wray Valenzuela, and I believe he testified previously. Yeah, with Maricopa County. We heard from him. Scott Jarrett's coming back. Bill Gates, onesie-twosie Bill Gates, who has PTSD now for running a terrible election, is apparently going to be testifying. Chris Hansel is also going to talk about signature verification documents. Shelby Bush is going to be coming in to talk about authenticity of various records. Myers worked for Maricopa County during the election. Yvonne Nystrom about signature verifications, and somebody else called Jacqueline Onakekit is going to be also in court. So that is what we've got queued up. We know there will be a court reporter there tomorrow. The judge said, having considered the request for a court reporter, it is ordered that they be there starting on the 17th at 9 a.m. all the way through Friday, May 19th. And so, of course, we will be here covering it. Thank you for joining us as we do. We've got a nice backdrop. We're up to speed on exactly what to expect. We'll be here tomorrow to see how the judge rules on the level 2, level 3, level 1 issue. And we look forward to seeing you there. All right, my friends. That is it for us on the day. Whew. We got some good ground under our belts here. We're now prepared for Kari Lake, and we'll see what that trial has in store for us. We also know that Marjorie Taylor Greene submitted articles of impeachment, and the FBI doesn't care at all about what they have done to America. But now it's time to hear from you, to check in with our friends on YouTube, on Locals, on Telegram, on Rumble, and on Twitter, and see what you have to say about all of this and more. And hopefully you're going to be joining us tomorrow. Hopefully you're already subscribed and you've got your calendar set. 9 a.m. Arizona time is when we will be covering the trial. And so hopefully you join us. Should be noon Eastern and then the different calculations in between. All right. We've got some comments coming in. Patrick Parker's in the house. We also had Patrick Parker starting us off. He says, Rob, I would like to add a comment to a members only video. Zero would like to give the man who suffers from TDS extra chunky face chili. Extra chunky face. I don't know what that is. It's like dumping chili on your face. Is this like ALS ice bucket challenge? Chili on your face challenge from Patrick Parker. Sounds interesting. Yeah. And we had an interesting conversation this morning about Joe Walsh, who had a strange video screaming about Trump. Yeah, weird stuff going on. Anyways, Fred Pedamontes here says $2 super chat because I donated to Daniel Penny. Woo, that's great. Thank you, Fred Pedamonte, for that. Yeah, our Daniel Penny video, I think, went out this morning, and he's well over $2 million, which is going to provide for a very good defense, and that is very good news. Good to see you, Fred Pedamonte. We've got Michael Allen Hughes says the FBI needs cleansing from the top down. I think it's appropriate. I think it's always reasonable to ask about new leadership and about new structures. And if a current entity in our federal government's not working well and not serving the people, it's very American to say, hey, it's time to refresh that and maybe to change the government and how it all works a little bit, peacefully and politically. Patrick Parker says, really? How so? Is this a state constitution that the judge can overturn a state governor? I'm trying to think of what story that was in reference to. Oh, I see. Kari Lake. Yeah, the law apparently says if the judge finds that it meets that standard, he can just declare Katie Hobbs illegitimate, sign the document, voiding her certificate, and put Kari Lake in, which is why I think it's going to be a very tall order to get to. However, it's amazing that Kari Lake is fighting to expose all of this, and there will be, I think, good things to come as a result of all this nefariousness that's been rooted out. And remember, look, in many ways, this is not even about count 3 and signature verification claims at all. It's about exposing this on display so we can all see it. And really, a lot of the nefariousness occurred on election day when people couldn't vote. It was that delay. However it happened, it was the effect of the cumulative problems that disenfranchised Kari Lake voters at scale. And so what the judge is trying to do, and what the Katie Hobbs team is trying to do, is define those terms. Kari Lake wants big terms to be able to prove a broad scope. All the things added up in totality matter, whereas Katie Hobbs wants it very narrowed. What are you alleging specifically? And the judge is buying Katie Hobbs' interpretation of this and says, you got to get very specific. And if your complaint doesn't match what you're trying to prove, it's not going to be good enough. Matthew Rees is here. Thank you, Matthew, for the dono. Eddie Oliver is back in the house. He says, Rob, I still hold you personally accountable for the whole election debacle. I know. You stood idly by and let it happen. We don't do that here in Texas, says Eddie Oliver. I know. I am a terrible person here. I apologize to the nation for what I let happen in Arizona. I'll try not to let it happen again. Eddie says, also, Sergeant Perry is getting a pardon the Texas way. And so thank you very much to Eddie Oliver, who sent in those chats. And is that official? Sergeant Perry officially getting that? I saw that there was an investigation into that, but I didn't know if it was official. That is good news if it is official. And hey, let's see who else is here. Hey, Dolphin Fan is the man is in the house. And thank K Bean is doing some clipping for us over there. Thank you, K Bean, for clipping that for us. Says, big welcomes. Dolphin Fan is the man. Welcome to Bernal. Welcome to August. Welcome to Melissa. Welcome to Robert. And welcome to John Carroll, courtesy of Dolphin Fan is the man in the house. And Who else is here? Patrick Parker has been a member for almost 1 year, baby. 8 months. Thank you for being with us so long, Patrick. We appreciate you being here. And we love having you as a member. It's great. Oh, and hey, check this out too. And Patrick Parker is also donating membos to our community. Amazing. Bend Over. Welcome, Bend Over. We got Matthew Larkins is here. Grifty also got one. T. Oliver and James Hicks, all welcome, courtesy of our friend Patrick Parker. And if you're a member on YouTube, don't forget to grab the community, go to the community tab, grab the Telegram button link, and join us for our after party. Matthew Rees also sent in the very first super chat. And so big shout out to Matthew Rees. First time. Welcome. We love our first timers here. We love the first timers. Yeah, always drop those in the chat. And thank you to K Bean who sent all of those in, and Donut Mind Me, appreciate, and Vienticus. Thank you to our mods in the house over modding the fort down for us. Let's say hello to Rumble. Let's say hello to Telegram. And then we're going to wrap it up and go over to our after party on Locals and on Telegram. Who's over there? Army Brats in the house. Jan X laughing my AO at Bend Over. Yeah, Bend Over joined our community. Jan X here. Jacob says, all hail Bend Over. Rumble's having fun. Bend Over's, coming into our community. Welcome. Should be fun. Next it says, trust me, Rob. Rob appreciates everyone being here. Yeah, and don't beat, and don't beat yourself. Yes, exactly right. Next it says, don't beat yourself up if you can't support the show. Totally agree with that. Yeah, I'm just glad that you're here. Just come on by. Don't feel any obligations at all. We're glad that you're here. Jan X here. Army Brats here. Indoctrination's in the house. Larry 1. It's good to see everybody. And hey, I saw this one come in from Curtis Bartle. Says, what happened to the guy at the border? Forgot his name. You're talking about the Arizona rancher, George Allen Kelly, I think. George Allen Kelly, the Arizona rancher. What happened to him? It's major sort of hiatus. I don't think we're scheduled for months on disclosure. So I don't think anything has really come up on that one. But that's George Allen Kelly, the Arizona rancher. And I think it's pretty much quiet right now. I'm signed up to get updates on that case, and I haven't seen anything recently. So not much there. We also have, but there will be more there. And that one came in from Curtis Bartle. Thank you, Curtis, for sending that one. Yes, okay. Hey, and Woods Precision Arms is in the house. Actually, I think that might have been from yesterday, or well, I don't know where this came in. This one looks good. It says, after Clinton walked after she destroyed subpoena evidence, broke the law, and lied under oath, I knew then no Democrat would ever get indicted. I just told everyone the Durham probe was just flash BS. From Woods Precision Arms. Yeah, I mean, the Durham thing is looking like about what we expected. Durham is, all of these people are lifers in the Justice Department, at the FBI and the DOJ. I mean, it's very hard to get them to do anything against their own, even if they are special counsel, unless you're Democrats. I mean, the Democrats are pretty aggressive, and they go after everybody pretty aggressively. But yeah, good comment from Woods Precision Arms. And we appreciate you, and thank you, everybody who sent in those amazing donos. We appreciate you. Let's say hello to our friends on Twitter before we go over to our after party. Is anybody watching over here on Twitter? We've got 4 people. It's amazing. We're almost at 5. It's getting out of control. If you're not already following us over on Twitter, come and join us. It's where you can also follow other watchers on Twitter, like Vienticus Prime. He says so much in court is wasted by spaghetti. Yeah. I'm not real sure what that means, but it's probably true. Danny says, the real John Durham report, they lied. That's all you get. And he says, nothing is going to happen with the FBI. TJ King says, often forgotten is Petraeus. And a lot of this stuff was hid, siloed. all to clear the way for CIA boss Brennan, who was a political hatchet man for domestic spying. Troublemaker Jonah says Merrick Garland was the one who prosecuted Timothy McVeigh. Says he's very, very much deep state. And the FBI could have made a simpler statement, according to Kate Relaya. Says the FBI could have used a simpler statement called sorry, not sorry. Womp womp. Exactly right. Tesla owner says 9 viewers say Walsh Freedom grabs his own purse. He had a very interesting post, that Joe Walsh. He said the most interesting thing about it is that he said that Joe Biden can put together 8 or 9 sentences coherently, which is obviously not true. So I'm not sure what president he's working with. But anyways, those came over from our friends at Watching the Watcher. Oh, hey, this one came in from Jackie Carey. And thank you, Jackie. Says, love you, Rob. Love you back, Jackie. Thank you for all that you do. Jackie's been a member for 1 month. We're grateful to have you. Thanks for being here, Jackie. And we love you right back. So, all right, my friends. Well, that is it for us on the day. I think we said hello to all of our friends. And now it's time to retire over to our after party at watchingthewatchers.locals.com. And if you're interested in more live streams, more content, come and join us. Become a member. Join on YouTube or join on Locals. We do member-only morning streams, smaller groups, a little bit more casual, organic. We just go through the headlines. It's a lot of fun. So come check it out, watchingthewatchers.locals.com, and we'd love to have you. Or join on YouTube and join us for the same things. Also, don't forget to get your Field of Greens over courtesy of our friends at fieldofgreens.com. They've got real organic superfood and all their different products that you will enjoy that will make you feel healthy and well. And the vegetables want to be eaten. We want you to be bursting with green energy, the good kind, so that you're healthy and well. And also, if you're interested in this mind map software because you want to get your mind mapped out and nicely organized, check it out, spotlightlawyer.com/mindmap. You can sign up for a free account, and it's a lot of fun, easy to use, and I love it. Also, want to thank the mods and our meme smiths. Big shout outs to our friend Vienticus Prime, K Bean in the house, Just Cause, we've got Playin' Hooky, Ronnie Cole, Zulu, Geomancy, Zach Nichols, John Allen, Janek 909, Dog Digger, we have Donut Mind Me, and our meme smiths, Sleepy Dog Lee and Geegum Geegum over on Locals. And we are grateful for everybody who is a part of our show today. Thanks for helping to keep the train on the tracks and joining us. We will be back here tomorrow, 9 a.m., to see what Kari Lake has in store for us. Evidence being presented in a new trial out of Maricopa County Superior Court. And so we'll have a full day. I hope to see you right back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. I'll see you right back here bright and early in the morning. Until then, be well. Bye-bye.